Hello, everyone, and welcome back to The Docket. I'm Bob Warwick. The Docket deals with legal issues affecting our community, explains legal concepts in an easily understandable way, and hopefully answers some of the questions you might have. So let's get started. Welcome, Your Honor. Thank you for coming here today and sharing your expertise about the Eighth Court of Appeals. I think most of the people in our audience have an idea, if for nothing else from television, how a trial court is run. Very few people have any connection to an appellate court. So let's get some of the basics out of the way. Can you explain what kind of cases come in front of you?
We do appeals. We're an appellate court. So as a result, we don't conduct trials, we don't have hearings, we don't take any evidence. So normally what happens is if a litigant or a party is in a trial court, civil or criminal, and they have a decision by the trial judge and they want to appeal that decision because they think it's incorrect, then they would appeal it to the Eighth Court of Appeals here in El Paso.
And are there requirements that the parties have to meet to appeal a case?
They would have to, the case would have to originate out of our jurisdiction, and we cover 17 counties, which is El Paso County and plus 16 other West Texas counties that are contiguous to El Paso County. They would have to file a notice of appeal.
I'm going to be asking you questions. I have very little contact with the appellate court. I think maybe once in my career I was involved in an appeal. And I think people are going to be confused when you say you don't take evidence, you don't listen to litigants. What do you base your decisions on then?
That's a really good question. So normally what happens is when either civil or criminal case, somebody is not happy with the result or the decision, they have to say the trial judge made a mistake. She or he made an error in their ruling because there's no basis in the evidence or because they misapplied the law. And so for those reasons, what they'll do is they'll file a notice of appeal, and all of the clerk's record, which is all the papers that are filed in a lawsuit, the court reporter's record, which is all of the testimony and all of the arguments that have been made to the trial judge, will be forwarded to our court. And then the parties will have their lawyers write briefs that will argue either the evidence or the law was incorrect and the trial judge made a mistake.
So what you can, I think, send it back to the trial court for a new trial?
There are a variety of things that we can do. Firstly, obviously, we can say the trial judge did not commit error and affirm the judgment. We can send it back for a new trial. In criminal cases, we could say, which happens very rarely, and I've done it on one occasion, we could say it's not a crime or there's not enough evidence and that person can go free. And in civil cases, we could arrive to a different decision and we could send it back to the court to enforce a different decision that we've made.
Enforce the decision made by the appellate court.
Right.
Generally, if you can even answer this, is it more common to send it back to the court to retry the issues, or is it more common to send it back and say, you were wrong, we're making the right decision?
I think it's more common to remand it for either a new hearing or a new trial. Generally speaking, we don't normally reach a different decision and have the trial court enforce that decision. That's pretty rare.
And when it goes back, that also, if the trial court came up with a decision, got appealed to you, and you send it, I think it's called a remand?
Right.
You send it back to the trial court, that also gives the parties a chance to revisit everything, and they could conceivably settle it without going back to court. Is that correct?
Absolutely. Absolutely. I mean, that's, normally that's true for civil cases. They always have the opportunity to settle it before we've reached a decision, or if we remand it back down to the trial court for a new hearing or whatever the case may be. So they always have that possibility.
And so how does something get appealed from your decision?
So from our decision, we're called an intermediate court of appeals because we're directly above the trial courts. But above us, in Texas, we have two higher courts. They are the Texas Supreme Court and the Texas Court of Criminal Appeals. Texas Supreme Court hears all of the civil appeals, and the Texas Court of Criminal Appeals hears all of the criminal appeals. And those are the two highest courts. Once you've appealed us to one of those courts, then if you want to continue the appellate process, and if the law allows you to, you can switch over to the federal system.
No, explain that a little bit, because I got lost.
Okay, so for instance, if and mainly I'm thinking about criminal cases. If you have a criminal case and you've appealed it to the Texas to the Texas Court of Criminal Appeals, and they've rendered a decision, and you still think it's incorrect, and if you have a basis in federal law, federal criminal law, you can then file a writ of habeas corpus in the federal courts and then start going up from the federal courts to the Fifth Circuit to the U.S. Supreme Court.
So it takes it to a different appellate process.
Exactly. Well, a different system.
Okay. So explain how your court's set up.
We are a 3-panel court, so there are 3 judges. We're one of the smallest courts in Texas.
Even though you have 17 counties.
Even though we have 17 counties, you have to have a minimum of 3 on a panel. There are some courts, I think the 4th Court of Appeals, which is San Antonio, they have 5 justices. In Houston, they have 1. Houston court has 9 justices. And so here in El Paso, we have 3, and I'm 1 vote out of 3. As Chief Justice, I think sometimes there's this idea that I have more a say in terms of the opinions, but I don't. We each have a vote, and so the case is decided in accordance with that vote. As Chief Justice, I am a justice and I have my vote, but I am also the administrative head of the 8th Court of Appeals.
How are the How are the cases allocated?
Randomly, each of us get 1/3.
And then how do you go about the process? I mean, do you meet? Do you discuss them? Do you first come up with your opinion before you discuss them? How do you finally get to the final vote?
Obviously it depends on the case. For the majority of our cases, each judge or justice takes their 1/3 cases and works on them in their chambers. And generally when they've arrived at a decision or a draft, they circulate that to the other 2. And then we vote either to go with the proposed draft, or at that point, sometimes you'll agree, but maybe you'll have some issues with some of the language, and we'll massage it so that it more accurately reflects the panel. You can write a concurrence, a dissent, if you don't agree with the conclusion or the analysis. And so once we vote on it, and then people write a concurrence or dissent if they choose to or not, then it gets issued.
What happens if the judge who the case was given to feels one way and the other 2 judges feel differently?
So then that case flips. So then what happens is that particular judge will become the dissent, and one of the other 2 judges then has to write the majority.
So as long as it's basically majority rules.
Exactly.
Would you explain also how cases, when you go and research cases, when I go and research a case, I'm looking at cases that have been appealed, correct?
Right.
I'm not looking at the trial court process.
Right.
How do people, what do people look for when they are researching a case?
Well, obviously, it depends on what is the error that's alleged. A party could say, well, the trial court misunderstood the law or applied the wrong law. And so what you normally do is you go and look for cases that have been decided that are precedent. In other words, they're cases that we must follow because we are an intermediate court of appeals. So we have to follow whatever the Texas Supreme Court says or whatever the Texas Court of Criminal Appeals says. So we look for those cases that are going to be dealing with that same kind of error and probably the same kind of fact pattern or as close as we can get to it to see what kind of decision did they render and how. How did they, it's kind of like your math. Okay, we got the answer, we have the answer, why?
It's like Jeopardy.
Right. So we have to say why. And so those are the kinds of cases that we look at. We obviously look at our sister court of appeals. Those cases are not precedent for us, but they're persuasive. And of course, any Eighth Court of Appeals cases that have been decided previously are precedent for us, and U.S. Supreme Court cases.
Now, what happens if you feel like the law needs to be changed?
That's a difficult issue, because if I've taken an oath to uphold the laws of Texas and the Constitution of Texas and the United States. So if there's precedent, either from the U.S. Supreme Court or the Texas Supreme Court or the Texas Court of Criminal Appeals, and let's say I don't agree with it, I still have to follow the law.
Well, then the next question is the law is a very fluid sort of thing, and it constantly changes. How does it change then if you're bound by the precedent?
Well, you're right. The law's organic, right? So the only way that you can do that is by distinguishing that precedent and saying it doesn't apply in this situation because the situation is too different.
Then that could be appealed to another court.
Right. They could say, no, it's not distinguishable. If it's an issue of first impression, that is, there really isn't any case law to guide us. There are, especially in the civil area, there are a number of cases, you'd be surprised, where there isn't really any case law to guide us, and we have to formulate a decision in which there's a particular statute that it's never been interpreted before. And so we have to do that for the first time. And, as a lawyer, you just take the concepts that you've been taught in law school and apply that with statutory interpretation in order to reach, hopefully, the correct result.
And the reason I think this is important to talk about is we need people to understand that this is where the law is made.
It absolutely is. Obviously, issues of first impression, cases that can be distinguished that are very different, the law is being made at the Eighth Court of Appeals here in El Paso, Texas. As
long as it's not reversed, if it's appealed, it basically becomes the law, and that sets the precedent.
Absolutely. If it gets appealed, the higher courts can either hear the case, accept the case, or they can refuse to hear it. And generally, if they refuse to hear it, there's some idea that they are, in effect, affirming what the Court of Appeals has done, or ratifying that decision, or approving that decision.
So we've talked, and then that again becomes the law, and that's the precedent that future appeals would be based on.
That's exactly right.
And that's what would be used as a, excuse me, the lawyers in the trial court would know that that's the law, and that would be what they would be trying to get to.
Right.
Is that right?
Right. And the thing to remember is we have 14 courts of appeals across the state of Texas. The Eighth Court of Appeals makes the law for the 17 counties. So whatever we write, and it's an issue of first impression that hasn't been written anywhere, or no, even in fact, if it has, whatever we say is precedent for all of the trial courts in these 17 counties.
And I do understand when you're a judge, whether you're a trial judge or an appellate judge, you need to set your own personal opinion aside and follow the law. Is that right?
Absolutely.
But very often, and I'm not trying to put you on the spot, and I know you wouldn't let me put you on the spot, but very often, I think this is just how society works. We progress. And if there's been a law in place that was good for a certain period of time, but as we've progressed as a society, that's kind of become outmoded, the justices can figure out a way to make it more current, to make it more functional with the way society is going now. Is that right?
If there's enough room for interpretation and argument, and you want to change the interpretation and it's distinguishable from the precedent, you can distinguish it, you can move it in a different direction. But if it's clearly, clearly precedent and there's no way around it, then what you must do is, you have to uphold it and you have to apply that precedent. You can dissent from that. I could write a majority for the other judges, but I could then dissent from the majority and say, look, we had to follow the precedent because we're in the Intermediate Court of Appeals, and this is what we're bound to do. I think, however, the law should be changed for these reasons. And I could write an opinion in the hopes that when it got appealed, if it got appealed, that the Texas Supreme Court would look at that, or the Texas Court of Criminal Appeals, and maybe it could influence them.
And now I'm getting into areas I really don't know much about, so you can educate me, as you normally do. Would it be something then, let's say you wrote a dissent, would it then be, and the legislature liked your dissent, would it be up to the legislature to change the statute, and then the law would be based on a new statute?
Yes.
Okay. So that's another way that the law can get changed.
It absolutely can. Sometimes, and I say this, I feel like if I write a dissent, I feel very strongly about something. To me, it's a message in a bottle, and I throw it into the ocean in the hopes that somewhere, somehow, somebody reads it and either adopts it in opinion and helps persuade or change the law, or it's legislatively changed.
It's interesting. It's difficult and it's complicated, but it's very interesting. Tell me a little bit about your support staff and how that works.
Well, we have, each chambers has 2 staff attorneys. So those are 6 court staff attorneys. We have a chief staff attorney, and we also have somebody we call a pool attorney, who's kind of a pinch hitter or substitute to come in and help different chambers depending. We have legal assistants who check the drafts and issue the opinions, and then we have a clerk of the court, and she is the 8th Court of Appeals clerk is Elizabeth Flores, and she has 3 deputies underneath her. And so make sure I don't forget anybody.
And it's very structured when you want to file an appeal, correct? There are time limits, there are things you have to do, there are ways you have to do it. Who sets all of that up?
All of that is set with the Texas Rules of Appellate Procedure, which are, just like the Texas Rules of Civil Procedure, are all legislative. And so normally you have a 30-day deadline for most appeals.
That's with the time within which you must file the appeal?
You must file
from the
a
trial
notice
court.
of appeal. There are shorter and longer deadlines depending. CPS cases, for instance, I think they're still 30 days, but we have accelerated appeal times for them, and so it's just it's just a notice. It can just be something written on a piece of paper that says, I want to appeal this case, and that's it.
You don't have to have any special qualification to appear in front of the appellate court.
No, I mean, obviously you have to either, if you're appealing for behalf of a party, you've got to be licensed in the state of Texas,
right,
or have permission to practice in front of us if you're licensed from another state. But we have our fair share of pro se appellants.
Do you really?
Oh yeah, on appeals, and yeah, for Yeah, yes, we do.
You mentioned to me, I think a while ago, that you are often giving cases from other parts of Texas. Is that right?
Well, there are 80 justices across the state in the 14 courts of appeals, and some courts of appeals receive a lot more appeals than other courts of appeals.
Just based on population?
Just based on population. I mean, Houston, I mean, it's in the urban areas generally, you know, Dallas, Fort Worth, Austin, Houston, San Antonio. And so what happens is the Texas Supreme Court basically looks at the number of cases in each court of appeals and equalizes that. So here in Texas, here in El Paso, because we're a smaller court and because we don't have the population that you do in Houston, for instance, we do often get a number of transfer cases from all around the state. I think last week the Texas Supreme Court entered a transfer order in which they're going to transfer 19 cases from Waco to us. We get cases from Eastland, Austin, Houston. So we do cases from all around the state.
And so you might be doing cases, let's use oil and gas, for example. We don't have a lot of oil and gas out here, but if you're getting cases from the Permian Basin sent here, you've kind of got to get up to speed on that sort of stuff.
Well, you know, the 17 counties include a lot of counties that have, you know, that one of their major industries is oil and gas.
Okay.
So we do get quite a few oil and gas cases coming, not out of El Paso County, but out of Pecos or Ector County, and so we get a lot of, we get our fair of oil and gas cases.
Do you get stuff, I mean, from East Texas also?
Occasionally, not very often, but yeah, occasionally, because you have Beaumont and Tyler and Texarkana.
And just as an aside, prior to COVID, I mean, people would come and appear in front of you. How do you handle this now?
Normally, the only court that we conduct are oral arguments. And for those of your viewers who have ever seen the United States Supreme Court conduct oral argument, that is basically the only type of court we hold, the only kinds of hearings. And so we conduct oral argument one day a month for about 10 months out of the year. And normally lawyers would come to the courthouse. We have a courtroom, and they would have oral argument before the three of us as a panel. But since the advent of the pandemic, we have been doing that by Zoom. And we also have that broadcast on YouTube. And so if you go to YouTube and look up the Eighth Court of Appeals, we have a channel with all of the oral argument there preserved. Oh. So, you know.
Well, we're going to be on YouTube also. But let's go back and talk about that for a second, because I meant to talk about this in the very beginning when you were explaining it. You grant oral argument in very few cases, is that correct?
That is correct.
And is that because you feel you can make, or not you, but the court can make its decision based solely on what has been submitted to you in writing? So
that you have an understanding. So once all of the documents, all of the paperwork that's in a particular case have been filed with us, so we can look at that. Once we have the transcript of all of the court proceedings, and then each party, and usually there's two parties, it's the appellant, the person who's appealing it, and the appellee, who's the respondent in the appeal, have to file briefs, which are kind of like research papers in which they explain to us, based on the evidence and the facts in the case and the law, of how the trial judge committed error. And then based on that, we research, we read all of that, and then we render a written opinion on a decision. And we say, here are the facts, here's the law, here's how we have applied the law, and here's our decision. So in the majority of our cases, we do those, we call them waivers, because oral argument is waived.
You determine, though, that oral argument is waived.
Right. And so normally what the parties can do if they want to is ask for oral argument. If parties ask for oral argument, then that case will be reviewed as to whether or not we will grant oral argument. I will tell you that normally the kinds of cases that we grant oral argument for are novel cases, first impression legally, cases that have some kind of historical or community interest, some kind of notoriety here in El Paso, or really complicated cases where it's helpful to have the attorneys so that we can ask them questions. Because at oral argument, it's a conversation. The lawyers are making arguments for and behalf of their clients, and we have the opportunity to ask them questions and explain to them what concerns we have that they may be able to address, and it's a conversation.
And I want to go back again. I keep going back to the beginning when you explained it all, and I just want to expand on it some. So you talked about an appeal from your court to either the Court of Civil Appeals or the Court of Criminal Appeals. Is that
It's the
correct?
Texas Supreme Court or the Court of Criminal Appeals.
Texas Supreme Court, rather.
Right.
Okay. Why is that distinction made when they go up from you? Because you can hear both civil and criminal.
Right. Our jurisdiction, or the authority that we have to hear cases, it's really, like the medical profession, I think legally, we have lawyers, we specialize normally. I mean, you've done real estate and probate and guardianship, but you've never done or very rarely, a criminal case or a family law
Right.
case, those kinds of things. At the Eighth Court of Appeals, you really have to be a jack of all trades, because we do cases, appeals from traffic tickets, appeals from evictions, up to capital murders that are not death penalty cases, and we do every kind of civil appeal, regardless of the jurisdiction. We do every kind of civil appeal, ranging from appeals originating out of Justice of the Peace courts up to district courts. We have done oil and gas cases that were in excess of $1 billion. So it's really the breadth of the cases that we do is it's just astounding. And then what happens is, if somebody's going to appeal us in Texas, we have these two Supreme Courts, if you will, one for civil cases and one for criminal appeals. I will tell you that out of the 50 states, I think there's only a handful of states that have those two courts. Most states have one Supreme Court that handles civil and criminal.
Oh, and you mentioned death penalty. What happens with it? Does that go to you, or does that immediately go to the Texas Court of Criminal Appeals?
It did, but they changed the law, I want to say about at least 15 years ago, where if an individual, a defendant, is assessed the death penalty, it skips the Intermediate Court of Appeals and goes straight to the Texas Court of Criminal Appeals.
And I think in a death, don't attorneys have to be certified to try
Yes.
death cases?
Yes.
And only a certain number in the entire state are certified to do that?
Here in El Paso, it's just a handful of attorneys that are death penalty qualified.
I would not want that responsibility. Let me tell you. And one other very basic fact: the appellant is. So we're coming out of the trial court now, and it's going to be appealed. What party is the appellant?
The appellant is the party who's unhappy.
Okay.
The appellant is the person who's appealing and thinks that the trial court made an error and is asking for some kind of relief, and they want something changed.
And the appellee is the one who won in the trial court.
Exactly.
Okay. Man, let me tell you, it sounds like a difficult, important, complicated position to be in, and to be the Chief Justice is something. So I congratulate you. I thank you for coming, and I hope we've cleared everything, not everything. I hope we've cleared a lot up for people who had questions about the appellate court. Thanks for coming, Judge.
You're very welcome.